I mean, invariably, I mean, there's a lot of things that are wrong with criminal law and criminal justice, especially in the United States. The police have too much discretion. Judges have too much discretion. Prosecutors have too much discretion. Legislators, I mean, you name it. There's always somebody had too much discretion. The AI thing for me was very interesting because people said, oh, well, you couldn't possibly use an algorithm because that would take away discretion. Question, why do I think accuracy is overrated here? I think is overrated because we don't agree on why we're punishing people. Better sense of accuracy would be, let's not predict anything about the criminals, about the offenders. Let's predict the judges. So I think sentencing fundamentally is not guessing how many jelly beans are in the jar. My suspicion is that within a relatively short amount of time, it's no longer going to be the question of like whether AI tools should be used in legal proceedings, but how exactly. You know, I try to imagine like what it was like to be living in Europe when the printing press was invented. I think if you went back in time and interviewed somebody at that time, they probably have no like real idea what was going to happen. We're over the cliff. I think it could be really exciting. Like it could be scary, and I could see a lot of ways in which it would go badly, but I can also see a lot of ways in which it could really be really great.
Welcome to the Just AI JMCE podcast, where esteemed experts from across the globe address the most pressing issues on AI technologies, their regulation, and the resolution of disputes involving them. Innovation can be an enhancement, not a hindrance to procedural fairness. This key takeaway is at the heart of our latest podcast episode, featuring Vincent Chiao, professor at the University of Toronto. With a rich background in criminal law and procedure, Professor Chiao's original and insightful scholarship sheds light on the critical role of discretion, both for regulators when enacting procedural frameworks and perhaps more importantly for judges when incorporating AI systems into criminal sentencing. With a focus on accuracy and fairness trade-offs in judicial decision-making, Professor Chiao predicts that as AI systems become more robust, they could assist courts in delivering fairer verdicts. However, this raises an open question. How should we reinterpret and apply due process rights for litigants when courts integrate AI in their decision-making? The question in the future will not be whether to use AI, but how to use it in procedure, Professor Chiao observes. Join us as we delve into the thought-provoking insights on rethinking the status quo in criminal law and procedure. Discover how AI might address existing dysfunctions in the criminal justice system, and by extension, civil justice system, possibly paving the way for fair judicial outcomes. Welcome to the Just AI JMCE podcast. And today I have the pleasure and privilege to welcome Professor Vincent Chiao, professor at the University of Toronto. Vincent, welcome. It's a thrill to have you. Thank you for accepting our invitation, and I'm looking forward to our conversation today. We always begin our podcast by asking our guests to briefly present themselves. And in your case, I know that your background is in criminal law and criminal procedure. So could you tell us a little bit more about how that came about, how you became interested in that area, and then how you became interested in artificial intelligence from the vantage point of criminal law and criminal procedure? Yeah.
Sure. Thank you, Lupcho, for inviting me to be on this podcast. It's a pleasure and a delight. In terms of like how I got interested in this, prior to studying law, I studied philosophy, interested in social and political philosophy, and then when I started studying law, the area where those kinds of concerns seemed most powerfully articulated, I guess, was in the context of the criminal trial and punishment and some of those kinds of contexts. So that's how I kind of got interested in that area of law. And one of the things that, so I guess I should say, although I have spent my career here in Canada, I'm an American by birth and by training. So I studied law in the United States. And one of the things that's very interesting if you study law and criminal law in particular in the US, at least at the time I did, was that when you go around and talk to other lawyers and activists and academics about criminal law, I mean, invariably, I mean, there's a lot of things that are wrong with criminal law and criminal justice, especially in the United States. I mean, not only in the United States, but especially in the United States. Yeah. And American analysts often would say, "Well, the problem is there's too much discretion. Like the police have too much discretion, Judges have too much discretion. Prosecutors have too much discretion. Legislators, I mean, you name it. There's always somebody had too much discretion. And so the AI thing for me was very interesting because when people first really began talking about this in the criminal justice context, I don't know, maybe not even really 10 years ago, pretty recently, all of a sudden, everyone's attitude shifted and all people said, oh, well, you couldn't possibly use an algorithm because that would take away discretion. And so I just found that a really weird experience. And I thought I wanted to investigate that a little bit further.
Indeed, indeed. And I'm so glad you brought up discretion because I have a question regarding discretion, later on. But, to set the stage, I want to ask a question on your views in criminal law and criminal procedure theory. In your research, you rightly mentioned, if I understood it correctly, that we live in administrative states or unadministrative state, where the burden of moral responsibility seems to be largely placed on institutions, which, in standard criminal law, correct me if I'm wrong, but the focus is mainly on individual responsibility, right? And the moral responsibility being placed on individuals. So could you briefly kind of outline and explain how you view this dialectic between public law, but also subjective rights in your theoretical work on criminal law and criminal procedure?
Yeah, I'm happy to, delighted to. So I think you're referring to my book, Criminal Law in the Age of the Administrative State. And there, as you say, I'm really kind of trying to defend a view of the criminal law in the context of a very expansive state with a state with expansive regulatory powers, social welfare programs, states that are active in just a ton of areas of social life in a way that's unprecedented in human history. I think that really changes, or should change, how we think about law, including criminal law. So, as you noted, lawyers, we tend to think of the rights of individuals, the particular party before us, if you're a lawyer, the particular case before you, if you're a judge, the dispute, without a view to the bigger picture, right? So we're more like doctors than we are like, say, public health experts. So this is kind of that kind of analogy, if you will. And I think that makes total sense. I don't have any like objection to it or anything like that. But in the context of a state with expansive regulatory powers that's trying to achieve social aims, I think it's important to also have a kind of a sense of the bigger picture, how the individual rights fit into a bigger picture of the state's objectives, what we want the state to be doing. And so I guess my kind of approach to this, I think traditional legal analysis focuses a lot on rights, maybe to excess, to the point where we're don't have a way of thinking about this kind of bigger picture of what the states should be up to. So the way I tend to think of rights in this context is as a kind of damper, if you will. A damper meaning something that doesn't prevent change, but that slows down. It slows it down a bit. So I think of rights as kind of protecting the status quo, kind of making change a little bit more cumbersome, a little bit slower. And there's a lot of value to that in a lot of contexts, but it's also obviously possible to overdo it, right? And to kind of not understand as I say, the big picture. And part of the way to think about that, or the way I think about that, is that if your main concern is just to protect rights, just make sure we don't ever violate anybody's rights, and the kind of most reliable way of doing that is just don't do anything. Like just don't do anything, and you will not violate rights. But that seems like just inimical to why we have states, right? Why we have the regulatory state.
Yeah.
So that's kind of where I'm coming from on that picture.
Yeah. And, in that context, I wanted to talk a little bit about your work on agency, in general, but also in connection to AI. If I'm not mistaken, you have been critical of, standard views on agency in Anglo-American law. And I have a quote from your work on agency, which I found just brilliant and so relevant for, the debates that have been going on in AI circles apropos agency. And you say, well, there's no compelling reason to think our judgments of criminal responsibility are or should be held hostage to the theory of action, and I found that quite amusing to read that, and quite right. So could you please share your thoughts on how you view agency, and this element of volition in agency that I think that you were critical of? And that was also, this element of volition was also kind of central in the AI debates on agency. So how does your take on agency in criminal law kind of inform you and inform us, or how should it inform us in terms of how we approach agency in the field of AI?
Yeah, great. So I'm glad that resonated with you. I think so. I guess I would say, like, I'm fairly committed to the idea that kind of our status as legally accountable agents, anyway, so accountable under the law, is a social status. It's a part of our how we relate to each other, rather than, I would say, like an intrinsic feature of an individual psychology or how we're constituted. Like, there might be metaphysical facts about individuals that we might call volition, something like that. I don't really think that's so, but I don't think that's really as germane to the law. So when criminal lawyers say things like, "Oh, you can only be criminally responsible for a volitional act," I don't interpret them as referring to some highly individualistic metaphysical claim about voluntariness or action or something like that. I think they're saying something more like, well, we're only going to hold people criminally accountable if their behavior reflects a degree of choice or control that makes it reasonable to view them as legally responsible, given the context. So, I mean, so I think, like, when you turn to, like, accountability for AI related harms, like, I'm just not super motivated by the question, like, oh, does the AI have a volition of its own? Like, I don't, until we're at the level where we're dealing with, AGI, like, whatever that means exactly.
Yeah.
That might be a different question. But until we're there, I kind of think, like, the main question is, like, well, the person who, deployed the AI tool, who used it in a particular context, thereby caused some harm or violated someone's rights or something like that. The question, like, did that person have the degree of control over the operation of this AI that makes it reasonable to attribute the harm to him or her? And, like, maybe he doesn't, but maybe that itself could be culpable, right? Maybe if you deploy it in a way that that you won't have control over, that itself could be a basis for liability. But whether the tool itself has a volition, I'm less super motivated by, I guess.
Yes, I agree with you. I don't know whether I think in the early 2000s, Larry Solomon published a paper on the personhood of artificial intelligence systems. And then he said, well, they're missing something. And then that something for him was awareness or consciousness, of the, like, ethical impact, right? Or legal impact even of their quote unquote autonomous actions. Autonomous implying little or no human control. So would you agree with that view? It seems to be prevalent still, in the sense that if you look at the emerging regulation, procedural regulation of AI, we do tend to look at those systems as products, albeit intelligent. But in parallel, there was a very interesting and kind of original scholarship that emerged about personhood, right? So I think it was a great invitation for us to revisit kind of canonical notions of, like, what is a person and what is a human being and what is a volition, and how do we dabble with these concepts. So any thoughts on this, against the backdrop of the Solomon study that I just mentioned?
So I guess I should. It's an interesting fact about academics. I don't know if this is your experience. This is my experience. Any case is true to me, that academics are, like, disproportionately influenced by who our mentors were and what we read when we were, like, at the start of our career when we were young, right?
Right. Yeah.
So I mentioned that because I was I first started studying philosophy under the guidance of Richard Rorty, and I'm very much, I think, still in that kind of tradition. And a lot of this, where I tend to think like I'm very pragmatic about a lot of these questions.
Yeah.
Well, is an AI a person? Well, like, can we interact with AIs in ways that seem like roughly analogous to how we interact with paradigm cases of persons? Are they legally accountable? Well, does it make sense to structure our legal institutions to hold them accountable? Like, can they interact? And if they can, then like to me, that's the important part. And then like, is there this subjective experience of awareness of interiority? Like, I don't know. I don't know. I don't. That's a hard question. I don't know if it's relevant to the law. Like, I mean, we hold institutions and groups liable and accountable under law. We treat them as persons in that sense. That seems to work reasonably well. And I don't know if they have awareness. So
Yeah, sure. But I just wanted to throw that at you, just to kind of build up on the question about
yeah,
agency.
yeah,
But and just to flag that there is scholarship out there that actually focused on the aptitude, let's say, of
yes,
systems to
yeah,
to be aware of the ethical consequences, let's say, of their output.
Well, look, I mean, I don't know if you can have a conversation, say, with
Yeah,
ChatGPT about
sure.
an ethical dilemma or a legal problem, and it will say things that are generally pretty sensible and seem like it obviously doesn't get everything right,
Yeah.
but at some point it's going to be robust enough where it will make sense to say like, yeah, it's engaging in legal reasoning, it's engaging in ethical reasoning. Does it have a subjective experience of awareness? Again, I don't know, but
Yeah.
I think when you can have the kind of sophisticated conversation back and forth, it's robust across environments. As factors change, it changes its opinions.
Yeah.
Like, that seems like
Yeah,
good
sure.
enough, I would say.
Yeah, and in connection to that, and also to what you said earlier about discretion, well, discretion seems to me to be kind of one of the prominent themes in your work, in your scholarship, and you namely approached it through the vantage point of fairness, essentially seeking to uncover if and how fairness in, as you call it, the distribution of punishment can be avoided or reduced. Arbitraireness, essentially, in the distribution of punishment can be reduced. So, please tell us more about your take on like this fairness constraint in judicial sentencing and exercise of judicial discretion.
Yeah, yeah, yeah. So I think this is related to some of the broader questions, in some of your work about sort of accuracy as well in decision making. So I think of fairness and accuracy are kind of related. So when it comes to, so here's my overarching view about sentencing and how I think fairness fits into that. So I think of I don't know if this is an idiom that you have that might be a North American idiom about guessing how many jelly beans are in the jar. It's like a game where you guess how many candies are, and then everyone makes their guess 100 or 200, and then you can open up the jar and you count, and there's an objective answer as you can see who got closest, right? So I think sentencing fundamentally is not guessing how many jelly beans are in the jar. I think there's no objective answer as to what the correct sentence is for most people most of the time. So there's some correct. So if someone has stolen, a bottle of wine from the store, 30 years in jail is obviously that's incorrect. Someone's committed murder, probation, that's incorrect. But other than that, like, I think it's like really there's just no real correct answer. So I don't really think accuracy makes a whole lot of sense in this context. And so, why do I think there's no correct answer to this question? Why do I think accuracy is overrated here? I think it's overrated because we don't agree on why we're punishing people. So, basically, if you go and ask 10 people, like, why do we punish criminals? I think you'll get 10 different answers. So we're really super confident. Everyone agrees. I don't know, everyone, not people, but most people would agree that criminals should be punished, but we don't know why they should be punished. And if you don't know why they should be punished, it's really hard to say, well, what's the correct punishment? So that's my kind of like big picture view. And so I think, like, well, if accuracy is kind of hard to measure, how hard to operationalize here, maybe fairness is more important in comparison, just being consistent, being predictable, treating like cases alike. So I tend to think that this fairness constraint's a little bit underrated in this context, because so much of our law, so much of our rhetoric, so much scholarship is about let's try and get very individualized sentence, make sure we get the punishment that really fits the crime. And it's like, who could be against that? Like, nobody could be against that, but it doesn't have a lot of content, I think. So that's why I tend to think, let's try and do a little bit more to make sure we treat like cases alike.
Yeah. I understand what you mean. Since that I think that you consider accuracy as an attribute of the outcome of the judgment as such, and therefore correct me if I'm wrong, but I think you might understand it as more in terms of proportionality rather than accuracy in the epistemic sense. And indeed, the work that you referenced is, I also work on accuracy, but I work on accuracy in terms of evidence, which is, a whole nother ballgame. But, this interrelationship between fairness and accuracy is nevertheless relevant because finally in your work on algorithmic decision making, you do kind of analyze this trade-off, right, between accuracy and fairness. So can you tell us a little bit more about how you approach that trade-off? I mean, you already kind of hinted as to how you view it in general, in judicial decision making. But what happens when an AI is involved in the judicial decision making? What happens to that accuracy fairness trade-off? In particular, in what we call individualized tailoring of criminal sentences.
So I think you could have multiple different accuracy fairness trade-offs in this area, depending again like what it is specifically you're trying to do. So like if you're trying to say part of determining what a proportionate or a fit sentence would be is predicting the likelihood of recidivism on the part of a specific accused, right? Now there's a question about which accuracy would mean, like, if you predict this person will reoffend, like, are you right? Like, is this will this happen in the amount of time that you predict? And like, is you're confident in that well calibrated? Like that I can understand, and like we can sort of ask like how accurate that is versus things like fairness in terms of are the criteria you're using to predict, are they fair? So being a young man who's arrested of a violent crime is generally, that's a group kind of characteristics that are predictive, but you might feel a little bit like not great about using. Like, okay, that's one set of trade-offs there. Another, I think, is where so that's one way, and I think probably the most commonly discussed way of using AI in the sentencing context, and that the kind of accuracy, fairness trade-offs there. I think there's a more general kind of trade-off, though, one I think is a little bit less discussed, that I'm a little bit more interested in myself, which is that if you sort of take the bigger picture and say, well, like whatever is the case about someone's recidivism, when we're trying to figure out what the proportionate sentence is, the fit sentence, we're balancing a whole bunch of different, recidivism, the condemnation, general deterrence, rehabilitation, lots of different things, right? And that's like really hard to predict. It's really hard to even know what it would be to be accurate about that. So there, I think the accuracy of a better sense of accuracy would be, let's not predict anything about the criminals, about the offenders. Let's predict the judges, right? Let's figure out what's the typical judge going to do, right? Because if you're a judge, if you're a sentencing judge, well, all day long you are balancing these competing, incommensurable objectives in concrete cases and coming up with a particular number. Maybe we don't know how exactly if somebody's been arrested and on these for this crime and with this set of facts, like
Mhm.
what would be a typical expected sentence?
Mhm.
What would where's the median there? What kind of variance, right? So so I think that is a couple of fairness related benefits.
Yeah.
One is that, among other things, I think it facilitates access to justice, right?
Mhm.
For if you're criminal accused, a large part of the value of having a good lawyer is your lawyer can tell you what to expect. Like if you're convicted, this is what you should probably expect by way of punishment,
Yeah.
right? That and if you don't have a good lawyer, that's hard to know. And so I think just being able to systematize that is valuable. The other thing is I think you might be able to reduce the variance a little bit, right? If you just say, hey, like here you're a sentencing judge, here's you have discretion to sentence this person as you see fit, but just so you know, like the typical judge, your colleagues would generally sentence this person here, right?
Mm.
If you're going to do something really different, like you might want to think like, are there extraordinary facts here that justify that, or maybe
Mhm.
maybe go closer to the where cluster around the median, which I think kind of reducing variance might tend to make the process a little bit more predictable and a little bit more fair in that sense.
Mhm. 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 Yeah, yeah, yeah. I understand. I will get back to this issue toward the end of our conversation, but I just wanted to shift kind of the focus from the courts to the litigants because you also wrote on the obviously the due process safeguards, right, in criminal trials, and you focused on this concept of due process pragmatism, if I'm not mistaken. So suppose you were a litigant in a proceeding that involved an AI. You know, how would does first of all, how do you understand the due process pragmatism, and does that concept inform us on then what the right of that litigant would be, or what the rights of that litigant would be in terms of expecting a fair outcome, expecting a judge not to violate any principle of proportionality in their particular case, right? So could you elaborate a little bit on that?
Can I ask you, when you say involved, like in a litigation involving an AI, like
Yeah.
involved, what context do you mean?
Well, the first thing obviously that comes to mind is the compass use, right?
Okay.
The Loomis case.
Yeah.
And that case was actually very, very interesting, I think, from both your perspective and mine, from an evidence perspective, because essentially what the Supreme Court in Minnesota said was that it's merely a tool, that it does not necessarily affect the judge's discretion, but it informs the judge, right, in terms of what would be a fair outcome in that particular, in that, given the facts. We're not going to get into the facts, but anyway. So, but still, the question is, and this is where discretion comes into play. Well, how do you know how much a judge relied on the system? You know, and that presupposes, well, how much the judge actually thought that the output was trustworthy, ergo somewhat accurate, right? So, and I do get your point, and I do think you're right in terms of what we previously discussed in a previous question. But that was kind of like AI can indeed assist courts. This can be very, very beneficial, of course. But from the perspective of litigants, who will go before a court and say, well, I have due process rights, and as was mentioned in Loomis, but in other cases as well, if you're sanctioning me, sanction me based on accurate information, right? So this is why I wanted to kind of shift gears and pick your brain on on just the due process, and how does that will that change? Will that push us to rethink how how litigants should approach, courts, how courts should treat information, how, this whole idea of proportionality and fairness. So how does all of this tie into this this question of involvement of AI in the
Yeah.
ruling?
Yeah. That's a great question, Joe. I should say so. I defended this concept of kind of due process pragmatism as a kind of response to what in my opinion, some excessive formalism in the U.S. Supreme Court about when various procedural rights, when people should get various procedural rights, and they have this very formal categorization of some things as criminal, as punishments, and hence triggering procedures specifically set off for criminal defendants versus people who are not. And I think that's a little bit formalistic because if you are in custody because it's a commitment hearing versus you're in the same custody because someone's prosecuting you. Well, I mean, like from your point of view, it's like pretty similar. So that's the kind of sense of in which I come at this question of pragmatism. Now, we'll say when it comes to the AI context, I think some people might think my pragmatism becomes due process nihilism. So that's so I think the kind of questions that you raise. I think there's a couple of different issues going on. One is so like in the kind of context you mentioned, like so the Loomis context where the judge is getting, say, a risk score, maybe an algorithm or AI derived. I mean, Compass is not, but you can imagine AI derived risk score, and they're kind of using it to factor into their own discretionary judgment about what to do. This raises a couple of concerns. One that one of my co-authors, Martin Heslop, raised in a paper we wrote a couple of years ago, where you might, because you have this very open-ended discretion from the judge, and also a black box AI, the AI might be already taking into account, is very likely taking into account a lot of factors that the judge is also going to be taking account. So there's risk of double counting, right? Where so the risk score might already incorporate a lot of the things that the judge might, and that seems like a real problem. That definitely seems like a problem. And so there, I think you would need a little bit more structure in terms of saying, here's how you are supposed to use this tool, not just like read the report and do whatever you want, but like there's some specific things that you're supposed to way in which you're supposed to use it. So that makes, I'm totally on board with that. The other kind of aspect that you mentioned was like, oh, if I'm being, you're going to impose a punishment on me, you're going to do something that, affects my interests. I need you to do that on the basis of accurate information. That right seems very powerful. This is the part where I'm more, so going back to our start of our conversation, I think of this more institutionally than maybe legally. I don't necessarily think of that as a legal right in the first instance. Like it could be, but I think in the first instance, you want to know, like, let's suppose we've got Compass 2.0, right? That's predicting these. You want to know, like, is that a quality instrument? Like, if the judge who's been given this report, like, can the judge rely on that as being, right, as a high quality predictive tool that's trained on the relevant data sets, that's up to date, that's robust, it's not, some tool that was trained 20 years ago on a completely different population for a different stuff like this. That I think of as more kind of a regulatory objectives, or you need some sort of, say, licensing program, or say, here's a certificate of quality, like people who are area experts have vetted this program, have kicked the tires on it. That's why you can rely on it. And if you can do that, then I'm less worried about, like, can you show in an individual case, like, here's a specific, inputs, here's the operations it performed, here's why it got the outputs, right? There, I'm just not as concerned about that as an individual matter. I think it's more about kind of social and institutional matter.
Yes. And just as a side note, as I was listening to you talk, again, getting back to this interconnectedness between fairness and accuracy, the argument that was mentioned in Loomis, but it seems to be recurring actually in a lot of trials, that where judges use a system, or public authorities like police authorities, when they use AI. Well, the litigant's stance is always, it's the output is inaccurate. You have relied automatically, so there's no human decision per se, and the output is inaccurate because it is biased. So biases always come to the forefront, and biases seem to be, seem to take up a lot of mental space
Yeah,
in
sure.
many researchers' minds, that work on AI. So yes, I do agree with you that it is an institutional and a regulatory issue first and foremost. But then, you will, or I think we will increasingly have people that will, whip out the bias argument to say this isn't right, not knowing whether it is biased or not, by the way,
Yeah.
but just a mere risk that it might be biased goes like, well, how do you know?
Yeah.
So, but those are my, parenthesis closed. Those are kind of my personal reflections on, how we approach accuracy, right? And fact accuracy, in proceedings, civil and criminal.
Yeah.
So, just in general terms, what are your thoughts now on involving new technologies at all in sentencing? You were, if memory serves, rather optimistic, and as you just mentioned, that it's in principle, if it's a robust system, there would be nothing wrong. But moving forward, do you think that this is something that should be advised, should be recommended? Do you think that AI will make criminal proceedings more transparent, more intelligible? You seem to have thought that when I was reading your paper on AI, but do you still think this is the case?
Yeah, it's a good question. I mean, what's the saying? It's always hard to predict the future, kind of thing, and especially about something like this where I mean, there's a big kind of variance between kind of the hype, I guess, and the realities. And I think we're still very early days, and then I think a lot of the kind of legal profession and the public institutions are very slow to adapt. So I don't really particularly want to have very confident predictions here. Also, I think there's just a big, huge data problem. A lot of the criminal justice data is very bad. A lot of the American data has a lot of problems with it. And then outside the US, the main problem is, as far as I understand, there's basically no data. And so I think that's just kind of hard. I am still, I think, in principle, optimistic about it. Although, like was part of that optimism in context. Part of the optimism is because I'm generally pretty pessimistic about the status quo. So it's like we're pretty low baseline. I think we might be able to make a little bit of improvement. Like that's basically attitude towards it. I would say, let me say something a little bit more general about this, if I may. I mean, I think one of the things that's useful for thinking about due process, about procedural fairness, from the AI context is precisely because AI is opaque and we don't have good explanations for it. But it seems to get right answers often, or plausible answers, right? Because if it gave dumb answers, and it's not interesting, it's stupid. What makes it interesting is if it gets what seem to be right answers, but we can't really explain why. And I think that puts a lot of pressure on I think the lawyerly focus on procedure, right? It's the if you can think, oh, procedure conduces to good outcomes, then you have a very good explanation of why procedure matters. Yes. But if you take them apart and you can, oh, I got good outcomes, but I don't understand the procedure, it's much less obvious why the procedure matters on its own. Yes. There's some things you don't want to torture people to get confession. Okay, that's fine. But some of these other things about you need an explanation of exactly how the algorithm maybe you do, but it's a little bit harder. So I think that's why this is really interesting area to think about, because it does make you think, well, it does suggest the possibility that we as lawyers, as legal academics, have maybe not attended as much as we should have to the fundamental question. Is like, it's important that the procedure conduces to correct outcomes, that being right is like pretty important. It's not the only thing, but it is.
Sure. And to kind of follow up on that, although you just mentioned that you're reticent to giving any assertions and confident predictions about the future, but how do you see the field of procedural fairness and criminal procedure and criminal law evolve in the future? Do you see strands or questions that scholars may be starting to think about or will be kind of encouraged to think about in the future? Before we started recording, I mentioned that at the time, for the time being, there are not that many procedural lawyers who are tackling AI issues, but I do have the feeling that it's becoming more prominent. These kind of procedural questions are coming to the forefront more and more. So from your field, from the vantage point of your field of expertise, how do you see, what are the most salient issues that come to mind, if any, down the line?
Yeah, I think so. My sense of this is that I think like with any like new technology, there's kind of an initial kind of phase of pushback and like, this is too weird and we don't like it. I don't know what's going on. And then as younger people like adopt it more and more, and it becomes just more customary part of life, then it's like it's taken for granted, and then we're just trying to figure out how to use it best. It's kind of like when GPS first came out. I remember people complaining, "Oh, now people don't know how to drive; they don't know how to read a map, and it's just so these young people don't know any." And now everybody uses GPS all the time, and nobody thinks about it, right?
Yeah.
So that's kind of my mental model of this. I think we're kind of somewhere in that early stages, and lawyers are, so lawyers who spent decades like with a particular understanding of what the litigation process was like, what adjudication was like, what fairness, procedural fairness means, like understandably feeling like the rug is being pulled out from under them and things are not making sense. But I think my suspicion is that within a relatively short amount of time, it's no longer going to be the question of like whether AI tools should be used in legal proceedings, but how exactly, and how we can compile them to some of our longstanding fundamental commitments about fairness, and like but maybe some of our commitments turn out to be not that fundamental, like some of our rights that we thought were really important. We think, well, maybe they don't matter as much now that we have a new kind of technology at hand. So that's the kind of like my big picture view of this, I guess.
And what about your own research? What lies ahead? What are the concepts or ideas that you're playing with or exploring right now? If you can disclose this,
absolutely. Yeah. So I'm working on I'm trying to start one. So I've got a paper coming out shortly about the rule of law of AI, and kind of making a very I think speculative would be the charitable word here. Very speculative argument about how technological change might affect the value that we place on the rule of law and sort of rule-based decision making. So if you think of rules as a type of social technology, then AI tools are just another type of technology, and they might be better suited to us in some ways. That could be very destabilizing, maybe in a good way, maybe in a bad way, maybe a little bit of both. So that's one project, and another has to do with sort of thinking about kind of going back to our start of our conversation, kind of the relationship between individual morality, individual rights as a means of sustaining a social order to broader institutional forms of social order, and sort of connecting our our evolved moral psychology to our understanding of formal order, formal rule-based social order. So that's kind of a different project.
Yes. So to conclude, what would be the takeaway given all of the things that we covered in this conversation, but also considering your forthcoming projects and publications? Would the main takeaway be not afraid, this too shall pass? Or be afraid and fine-tune the rule of law, fine-tune procedural fairness, fine-tune judicial discretion.
Yeah. I mean, maybe both, right? I mean, maybe both. I mean, it's just like, I try to imagine like what it was like to be, let's say, living in Europe when the printing press was invented, right?
Yes.
Or some transformative technology, I think if you went back in time and interviewed somebody at that time, they probably have no like real idea what was going to happen. Like even if they knew the precipice of some huge change, that's how I feel. Like we're over the cliff, or we're about to be over the cliff, and like
might as well.
That's the takeaways. Like I think it could be really exciting. Like it could be scary, and I could see a lot of ways in which it would go badly, but I can also see a lot of ways in which it could really be really great. And for me, I mean, sort of someone who's spent my career thinking about criminal law and criminal justice, like again, I say like a lot of the status quo is not great, and so I'm really trying to be optimistic about improvements.
Yes, great. Well, Vincent, unfortunately, this would be a wrap. It was an absolute delight to talk to you, and we'll be sure to monitor your work. And as you know, I'm an avid reader of everything that you publish and will publish. So, and again, thank you for accepting the invitation to be part of this podcast. We're delighted to have you.
Of course, it's my pleasure.
Thank you.
Thank you for watching an episode of the Just AI Jean Monnet podcast, brought to you by the team of the Just AI Jean Monnet Center of Excellence and supported by the European Commission through the Erasmus Plus program. Keep an eye out for upcoming podcast episodes where experts in the field of AI will delve into the significant risks posed by these technologies and propose potential solutions. Stay tuned for many exciting and insightful discussions to come.